Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5065, National Association of Realtors versus United States of America et al. At balance. Mr. Liu for the appellants, Mr. Michel for the appellate.
Mr. Liu, good morning.
Morning. May it please the court. Fred Liu for the United States. I reserve 2 minutes for rebuttal. There's no dispute that in November 2020, the Antitrust Division closed its investigation into NAR's participation rule and clear cooperation policy. The question is whether, in addition to agreeing to close its investigation, the division made a commitment not to reopen it. The answer is no. No such commitment appears in the text of the closing letter. The division repeatedly rejected such a commitment throughout negotiations, and the record shows that when the division does intend to make such a commitment, it does so in unmistakable language.
Can I ask you a question about that, please? If we disagree with you about that, can you still win? Or do you concede that that's the dispute, that's the case, what you just said?
No, we still win because the ordinary meaning of close, particularly when read in the context of the negotiation history of this case, is that closing did not entail any additional commitment not to reopen it.
Well, so I guess I'm saying if we disagree with you about that.
If you disagree with our reading of the...
Let's say we think that close was a promise to close it and keep it closed. If we disagree with you about that, do you have another theory where you can win, or do you concede that's the case?
That is our theory in this court, which is that when the Antitrust Division made the commitment to close, that did not apply any additional commitment to refrain from reopening. And that's clear throughout the record. The division repeatedly rejected any commitment not to reopen. This is at JA 248, at 252, at 259. Each time the question of whether there would be such a forward-looking commitment arose, it was rejected. And not just rejected like we said no, we rejected it categorically.
It seems like you kept rejecting it and they kept refusing to settle with you. And then you relented and you said, well, if you'll agree, not just to the consent decree, which I understand was never ultimately executed, but also to the proposed, the order and the temporary order and stipulation. It seems like they refused to agree to the order and stipulation until you gave them the promise to close. And then once you finally gave them the promise to close, they gave you consideration for that promise. And the consideration was their agreement to abide by the temporary order and stipulation, which required them to make some policy changes.
That is all correct. I think it just raises the question, what was the promise to close? None of what Your Honor said answers that question. When we relented and said we would agree to close, we did not relent on giving any sort of commitment to refrain from reopening. And the clearest place to see this in the record is JA 259. This is the August 12th letter from Michael Murray back to NAR. And the last sentence of that letter says, as I previously explained, we can't make any commitment not to reopen. And then the very next thing in the JA 260, is a letter from NAR back to the Antitrust Division dated August 18th. And it says, we accept the terms of that proposal.
So how do you respond to the analogy that NAR gives? A parent tells the child, close the door. The child does not obey that order by closing the door and then immediately reopening the door.
I think as NAR acknowledges on page 22 of its brief, context is critical. And the relevant context here is supplied by the back and forth communications between the two parties on this very issue. We rejected it 3 times. After the last time we rejected it, it's not like the parties moved or there was further negotiation. The very next communication from NAR is we accept. We accept what JA 259 tells us, as Michael Murray previously explained, no commitment to never investigate again. And in fact, if you look at the record, the very first time this idea that the closing letter could be read to contain some sort of commitment, some sort of limitation on the future exercise of executive branch discretion doesn't come up.
What was the closing letter worth? It seemed to be very important to NAR that they get what they got in the closing letter. What do you think it was worth?
I think there are 3 important benefits that NAR got from the closing letter, even as we interpret it. Number 1, as a practical matter, the closing of the investigation created inertia against reopening. And that's because there's an internal process within the division to decide when to reopen something. Now, it's true, as an ex-ante matter, you can't tell how much that practical benefit is. You don't know if it's going to be 2 months until the division decides to reopen, or it's going to be 2 years. But nonetheless, any delay in a new investigation coming up is a benefit.
That's not nothing. Maybe it's not nothing. What are the second and third?
The second benefit is the PR benefit. We saw this the day after we gave NAR the letter on November 19th. On November 20th, they took the letter and filed it in pending private litigation in the Central District of California involving the clear cooperation policy. And to this day, NAR continues to invoke this letter, I think to imply that the division doesn't have too much of a concern with the 2 policies at issue.
Sure.
And the third thing is they got the immediate benefit of not having to respond to the CIDs that were then pending. But I think, I was just going to say, I think it would be wrong to think of the closing letter as the only source of benefit that NAR got from this deal. You're right that they said we aren't going to sign on to the consent decree unless we get this closing letter. But parties all the time in deals say things like, we'll agree to this if you throw in one more thing.
Do you have any concern that what DOJ is doing here will make it harder for future DOJs to convince parties in NAR's shoes that when DOJ says it will close an investigation, it will stay closed for more than a half minute?
No, because we made clear throughout the process that we weren't making that commitment. So we're not concerned at all that in the future we won't be just as clear. We thought we were just as clear here. The only reason this contract isn't more specific is because NAR had no incentive to ask for more specificity. If they had, they already knew the answer. We would have
so
said.
much of your time, and I'm grateful to my colleagues for letting me have one more question. I think just one more. Why did DOJ do what it did in 2021? What explains it?
Well, I think we had 2 sets of policies in front of DOJ at that time. We had the 4 policies that ultimately became the subject of the proposed consent decree. And those were policies where the 2 parties were able to reach some sort of agreement. Then we had the 2 policies that were the subject of the closing letter, the clear cooperation policy and the participation rule. Those were policies that the parties remained far apart. And so I think the thinking of the division in November 2020 was, we got 2 months left, let's finish what we can. And so they finished their work on the 4 policies. And they said, our administration is ending in 2 months anyway. We're not going to be able to finish any investigation into these 2 policies. It's no skin off our back to agree to close them. It's a small price to pay for getting NAR's consent to the proposed judgment on these 4 things. But at no point did Macon Delrahim and Michael Murray think that they were binding the future exercise of executive discretion. It's not as if they repeatedly told NAR from July through August 2020 that they couldn't make that commitment, and then at the last minute did a 180 and did the very thing that they described repeatedly as a non-starter and contrary to department policies. That's simply not a plausible reading of this record. And to your last question, Judge Walker, about whether the department is concerned about the effect of this decision on future negotiations. I think it's completely the opposite. If something like the district court's decision is allowed to stand, it will destabilize our ability to negotiate these sorts of things. What the district court said was, I'm reading this document. I think NAR should have gotten more out of this deal than they actually got. I don't think this closing letter is really worth the piece of paper it's written on. So I'm going to read into the closing letter some sort of commitment.
Does DOJ ever do what NAR says they did here?
Absolutely, and I think it's not exactly the same, but the closest we will do to something like this is agree not to prosecute. And I think the difference is telling. Look at Exhibit K and L to NAR's reply in the district court. This is a model leniency letter from the Antitrust Division and a model plea agreement from the Antitrust Division. And in paragraph 3 of the letter and in paragraph 15 of the model plea agreement, you'll see the unmistakable sort of language we use when we do want to constrain future exercises of discretion. We say, quote, the United States agrees that it will not bring further charges. That's the sort of unmistakable language that's missing here. But I should also emphasize that what NAR thinks we gave up here is even more extraordinary than those plea agreements, because those plea agreements agree that we won't bring further charges for specified past conduct. The policies at issue here are ongoing potential violations of the antitrust laws. And I think as the OLC opinion that's cited by both parties and is attached as Exhibit A to NAR's reply below shows, this is pretty unusual, and you would think that when the executive does this, it would make its intention manifest. I see that I'm over my time.
So I want to go back to Judge Walker's first question, which was, are you relying on anything else? And it seems to me that there is a plausible argument that this closing letter, if it's part of an overall agreement that included the consent decree, was withdrawn when the consent decree was withdrawn. Are you not making that argument?
We're not pressing that argument as a standalone argument here, but I do think the history of the withdrawal and what it shows about why we withdrew supports our interpretation of the closing letter.
So you're just relying on your interpretation of the closing letter and not that it has been withdrawn.
Correct.
And on the unmistakability principle, you didn't raise that in the district court. Is that something that you're allowed to raise on appeal if you did not raise it in the
Yeah, I think so for 2 reasons. The first reason is this court, like the Supreme Court, has distinguished between issues and arguments, and it has said that so long as an issue was preserved below, a party can raise additional arguments relating to that issue. We view the relevant issue here as what the meaning of close was between the parties, and this is just an additional argument that supports it. The second reason is that the sort of unmistakability principle appears in Exhibit A to NAR's own reply that it submitted in the district court. This is the OLC opinion that on page 146 says that courts often construe executive branch settlements narrowly out of respect for executive branch prerogatives, and so as not to bind future administration. So NAR itself put this doctrine in front of the district court, and I think it's pretty fair that we get to rely on it too.
Thank you. A couple minutes of reply.
Appreciate it. Thank you.
Mr. Michelle.
Thank you, Your Honor, and may it please the court. Chris Michelle for Appellee National Association of Realtors. This case can be resolved on straightforward, narrow, common sense grounds. The government does not dispute that it entered into a binding contract with NAR. The government does not dispute that that contract required it to close its investigation into 2 enumerated NAR rules in return for valuable consideration. And the government does not dispute that it resumed that same investigation into those same rules, not because of any change in the rules or the law or the facts, but simply because DOJ changed its mind. As my friend Mr. Liu concedes this morning, DOJ's entire case depends on its contention that its binding promise to close the investigation left it with precisely the same unfettered discretion after it made that promise as it had before it made that promise. But under that reading, DOJ's promise would mean essentially nothing at all. And NAR's surrender of valuable consideration would make little sense.
Opposing counsel listed 3 things that you gained from the promise, even if you don't gain what you think you gained from the promise. What's your response to that argument?
Well, I think we didn't gain much of any value from any of the things Mr. Liu mentioned. I think the first thing he mentioned was some sort of inertia within the government. Of course, the letter didn't say, we will apply increased inertia against reopening the investigation. The letter said we will close the investigation. The PR benefits, again, that was not something that I think is memorialized in any of the negotiating history. And the third benefit, I can't quite recall what he said.
Going back to the first.
I just want to confirm, it's true though that your client has used that letter, submitted it in other cases.
We have publicized the letter, although I guess to take on, I think, the thrust of Judge Walker's question, even if the letter had some benefit, more than zero benefit, the question in the case is not whether the letter had any benefit. The question is what the parties bargained for. And I think there are multiple sources of contract meaning that indicate that the letter was worth more than, as the district courts, it had to be worth more than, as the district court said, the paper that it was printed on. I mean, I'd start with the ordinary meaning of the term close, particularly in the context of closing the investigation. The ordinary meaning of close is, of course, end or conclude. And I agree with my friend, Mr. Liu, that meaning depends on context. But in the context of an investigation, closing has to mean something more than the government having the same discretion that it had before it made the promise to close the investigation than it did after it made the promise to close the investigation. Otherwise, the promise doesn't mean anything.
But you're conceding now that your client did receive a benefit from being able to use this letter and publicize it and use it in other cases? Because I thought you started your argument by saying there would be no benefit to this if it wasn't also a commitment not to re-prosecute. But now you appear to be conceding that there were other benefits.
I'm sorry, Judge Pan, I didn't mean to, I concede that we did display the letter and publicize the letter. I don't think we derived any significant benefit from that, but I also don't think the case turns on that.
I understand. I just wanted to confirm what your position is. I thought you started saying it had no value.
To Judge Pan's point, it does seem like one of your strongest arguments would be if the government's right, then the promise was not worth the paper it was printed on. And maybe it was helpful in the way the government said as its second reason, but I think the first reason also seems like it might have been helpful to you, the inertia point. And, you might be a little bit more, we might be a little bit more transparent in how we think of the inertia point by saying you gained the benefit of being pretty confident that if the personnel and the antitrust division didn't change after the election, you'd be good to go. But you made that bet and you lost the bet.
Well, a couple of responses, Judge Walker. I think, of course, we're trying to determine what the words of the contract mean here. And the government's position, I don't take Mr. Liu to disagree with this, is that the government could have, consistent with its understanding of the letter, reopen the investigation immediately, the night of or the morning after it sent the closing letter. It's true that some time went by, but I don't, as Mr. Liu said this morning, I don't think he's making any argument that's based on how much time went by.
That would have been pretty inexplicable. And so you might have thought, that's very unlikely. Actually, what was the timing of the closing of this agreement?
It was in November of 2020.
When was it November 19th and November 20th?
I think that's correct. Yeah, okay. November 19th is the closing letter. Yeah.
One thing that the government pointed out is on JA 259, DOJ said that the antitrust division just cannot commit to never investigating, challenging the two rules in the future. And I think the government is suggesting when it said that, it just meant we don't have the power. Maybe we don't even have the constitutional authority to bind a future DOJ. What's your response to that?
Sure. Two responses. First, I do think the text matters. And the text says the division, this is page JA 259. The division cannot commit to never investigating or challenging NAR's rules and policies in the future. I mean, that is far more than we're asking for from this court or that the district court interpreted the letter to provide to us. We're not asking for a commitment to never investigate, and we're not asking for a commitment to never challenge NAR's rules and policies. We're talking about two specific enumerated rules and policies, and we've taken the position throughout the case that if those policies change in some way, the closing letter does not preclude the government from investigating those. So I think what Mr. Liu said was his best evidence ultimately doesn't show that the government rejected the interpretation of the closing letter that the district court adopted. Now, to your deeper, your broader question about the government's authority, I think it's frankly an alarming proposition that the government is saying it either doesn't have authority or gets some tremendous thumb on the scale anytime it sacrifices its enforcement discretion in an agreement with a private party. The government
It just has to do so clearly and unmistakably.
Our first submission is that it did so clearly and unmistakably
Okay,
here, but
let's talk about that, because I'm looking at the language of this letter and I don't see how you can read it to make any commitments about the future. It says the Antitrust Division has closed its investigation, talking about a particular investigation. And then it says NAR will have no obligation to respond to CID numbers. It gives you numbers issued on these particular dates. It's talking about a particular investigation and particular CIDs. It's not saying anything about any other investigation, any future investigation. It's not making any commitment about the future. And then it says no inference should be drawn from the division's decision to close its investigation into these rules, et cetera. I don't see how you can read into this any kind of commitment about not prosecuting in the future. The plain language.
I agree the plain language is critical here, Judge Pan, and I think the future tense plain language in the second sentence of the letter, it said after it says DOJ has closed the investigation, it then says accordingly, in other words, as a result of DOJ closing the investigation, NAR will have no obligation to respond to the two enumerated CIDs. I mean, that is,
the
of course,
enumerated CIDs. It doesn't say we can't issue another one.
it doesn't say they can't issue another one, although I don't even take the government to be taking the remarkable position that it could simply renumber the CIDs and ask for exactly the same
I'm just talking
information.
about this language. Where do you get, I will not in the future investigate you on these two policies?
Sure, two things together. The ordinary meaning, a number of things really, but the ordinary meaning of the word close, which we think implies something more than authority to immediately reopen, coupled with the future language.
Wait, don't gloss over that.
Okay.
The ordinary meaning of close means we close. It's closed. This one is closed. What does that say about reopening?
Sure, I think in the context of as I said earlier, in the context of an investigation, the commitment to close has to mean something more than the government retaining precisely the same.
Investigations are reopened all the time.
Investigations are reopened on occasion. I think the government at page 53 of its brief says, in the ordinary course, investigations are not reopened.
It's not unusual for investigations to be reopened.
It's certainly possible for investigations to be reopened, but is this
It is
court?
not unusual. Do you agree with that? I mean, I think there are cases cited. Isn't there a Seventh Circuit case, Shellingcraft or something? I mean, there are lots of
Sure,
examples of investigations being closed.
I think it's I agree with you, Judge Penn, that that's an important case to look at, the Seventh Circuit case. And there's a critical difference between that case and perhaps, the frequent reopenings that you're referring to. And in those cases, there's no contract. There's no exchange of consideration from the recipient of the promise to close.
Closed here. We're talking about the word closed.
Right.
And the plain and ordinary meaning of closed does not imply and will never reopen. All I'm saying is that things get reopened. It's not unusual. And so we're just talking about the meaning of this word. And given that this is not an unusual thing, how can you read closed to mean and we'll never open this again?
I think both in the context of the letter itself and in the context of the parties bargaining, for example, the district court found as a matter.
And get to the context if this is clear and unambiguous.
I think if it's clear and unambiguous against us, I'm not sure you would need to get to the.
Either way, if it's clear and unambiguous for or against.
Well, yeah, if it's clear and unambiguous for us, you don't need to look at it. No, but I do think it's an accepted principle of contract interpretation to look at the parties bargaining history. But even aside from the bargaining history.
Only.
And I agree, it's clear. We think it's clear and unambiguous in our favor. I mean, I would take, just to give another example of what I think is common sense that can be applied to understanding this.
If I close the door, does that mean I'm never going to open it again?
No, I agree there are contexts where it would make sense to reopen again. But as Judge Walker alluded to earlier, I think I can come up with hypotheticals where it would be quite surprising that you would immediately reopen it. For example, if
But we're not talking about immediately. You're saying that this says never again.
well, I want to be very clear, Judge Pan. I don't think Mr. Liu disagreed with this. The government's position is that it could reopen immediately. The courts.
I know that, but your position is they can never, ever in the future, ever reopen an investigation about clear cooperation policy or participation rule?
I'm sorry if I've left that impression. Our position is that they can reopen the investigation if there are any material changes in these policies.
Where's that in this letter?
I think that's an interpretation of what it means to
That's in the stipulated
refer to an
order.
investigation.
Isn't that in the stipulated order, stipulated temporary order?
That I think referred to what was in place between the time of the closing letter and the consent decree's entry. But yes, that was from there too. I mean, I was going to, just as a matter of common sense, there's a commitment in the closing and the consent decree that NAR will adopt certain rules that correct the policies that DOJ was objecting to. If NAR had adopted that rule and then repealed it the next day or the next week, I don't think DOJ would say the plain meaning of adopt was satisfied by what you did in this case. And I don't think DOJ would say, oh, you're improperly reading words in there by saying we didn't say adopt and not repeal. I think there's an ordinary common sense meaning here, particularly in the context of a bargained for closing of a law enforcement investigation that implies not immediate reopening with total discretion, which is the import of the government's position in this case. And of course, the government itself, and I don't fully understand Mr. Liu to disagree with this either, appeared to operate under the impression that it was constrained by its promises in this settlement. And that's why it didn't immediately reopen the investigation in 2021, as it could have if it believed the argument that it's advancing today. Instead, it went through a labored process of attempting to renegotiate the consent decree and ultimately withdrawing from the consent decree. And I think you should look at the government's actions and conduct in real time as opposed to its post hoc litigation rationale and determining what it itself understood the contract to mean. As this court has said, the party's conduct is often the best indicator of their understood meaning.
Can you respond briefly to the argument about the unmistakability doctrine that the government makes, the forfeiture part? The government says this canon is just like the expresso unius canon, and you can no more forfeit an unmistakability canon than you can the expresso unius canon. And
right.
Respond to this too, for better or worse, I think our court has some opinions saying even Chevron cannot be forfeited.
I think the better understanding of it is that it is a doctrine under which courts can trump the ordinary words of a contract. It's not just a canon of construction. I think it's rather unfair for the government to chide Judge Kelly for flouting the unmistakability doctrine when it didn't even mention it. So I do think the better understanding is it can be forfeited. But in all events, I don't think it applies here. I would just look at this court's parade of cases over the years interpreting contracts like this one, settlement agreements, plea bargains, without applying anything like the unmistakability doctrine.
If there's ever been a precedent that says the unmistakability doctrine can be forfeited?
I don't know if there's a precedent on that, Your Honor, but I do think I would look at, for example, this court's decision in the Moreno-Mambache case, which we cited, where this court interprets a plea agreement without any kind of unmistakability thumb on the scale. Judge Garland's opinion for the court, then Judge Garland's opinion for the court in Seeger versus Mukasey, where the government gave up hiring discretion, certainly a sovereign power, and the court, meticulously applied different canons of contract interpretation without any unmistakability. The Supreme Court's cases in ITT Continental Baking and United States versus Armor, two cases at the government sites that are about antitrust consent decrees. In other words, contracts in the antitrust space in which the government gave up enforcement discretion. There's no hint of the unmistakability doctrine there. So I think it would be candidly a radical expansion of the unmistakability doctrine to apply it to a simple exercise of enforcement discretion of the kind the government undertook in this case.
All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honors. Just a few quick points in rebuttal. First, about this discussion about JA 259 and the word never. My friend suggests that we merely rejected a very rigorous limit that said we would never investigate again. I don't think that squares with the record. The page on JA 259, Michael Murray is referring back to previous communications. If you look at the previous communication on 248, he is referring to a commitment not to challenge these rules in the future, and he calls it a non-starter. That is a categorical rejection, not just a rejection of one form of the limit. And then another thing that reinforces that is, again, what I said earlier. After Michael Murray on JA 259 says, we can't commit to never doing this again, it's not as if there were more negotiations toward some more modest limit that contains some material change language. No, after that, the very next communication is, we accept those terms. So there's no way to squeeze out a material change limitation from this record. The second point I just want to make is about the suggestion that the course of performance after the closing letters suggests that the government had a different view of the closing letter than we do today. That's simply untrue. After the closing letter was sent and after the government received comments through the Tuniak process, we looked at those comments, we thought about the proposed consent decree, we decided we wanted to withdraw. The reason we wanted to withdraw wasn't because we thought there was something wrong with the closing letter, which we viewed as a side deal and not even part of the Tuniak process. Rather, it was because we were concerned the proposed judgment itself might have res judicata effect that would preclude.
Can you point me to a precedent where the government has made a promise in exchange for consideration to close an investigation, and the court has said that the government can reopen the investigation?
Not in a case where we made a promise to do it, but there are cases where there are letters that say we're going to close an investigation, and the court doesn't construe those letters to mean that those investigations wouldn't open again.
Did those cases have consideration in exchange for a promise?
No, I'm thinking of the Seventh Circuit case in Schellenbach, which construes a closing letter.
You said today that there was consideration.
And there was consideration here. So I don't think the fact that the Schellenbach case didn't involve consideration means anything. I would analytically think of this in two pieces. One, did the United States make a commitment to close, a commitment? And we acknowledge that we made a commitment to close. And if you look at JA 20 to 21, NAR acknowledges that we closed. They say on JA 20 to 21, consistent with the terms of the agreement, the Antitrust Division closed the investigation. Then the question is, does the meaning of close encompass something broader? And I do think cases like Schellenbach, even though they don't involve an exchange of communication, are relevant to that ordinary meaning interpretation. I see that my time is up.
Thank you.
Thank you.
Case number 22-5295, Center for Biological Diversity et al. Versus National Marine Fisheries Service and Gina Raimondo in her official capacity as Secretary of Commerce. Mr. Eaton, Mr. McMardle for the appellees.
All right, Mr. Eaton, good morning.
Good morning, and may it please the court. My name is Chris Eaton for Appellant Conservation Groups. I'd like to reserve 2 minutes for rebuttal. When agencies regulate, they need to show their work and they need to give the public a chance to provide meaningful input. And we're here today because the Fisheries Service didn't do that when it came up with a new arbitrary standard for turtle excluder device requirements. That arbitrary standard does just a mere fraction of what the service has said is required to address the greatest human cause impediment to the recovery of sea turtles, particularly the most critically endangered turtle, the Kemp's red. And I'd like to begin with the notice and comment violation, because all of the claims in this case present problems.
Can I ask you to either get closer to the microphone?
My apologies.
Thank you.
I'd like to begin with the notice and comment violation because all of the claims in this case concern problems that might not have been an issue if only the service had given the public a chance to weigh in on the 40-foot standard. And I'll discuss the arbitrary justification issue second. So if an agency is going to announce a new standard in a final rule that defines which entities are going to be subject to a regulation, it has to have given some notice that a change to that ultimate standard was possible. Otherwise, interested parties can't know that they're supposed to comment on that subject or the issues that it raises. The proposed rule here gave no indication that the service might come up with a new regulatory standard in the final rule. And that new standard raises a bunch of new issues that just weren't in the mix for the approaches that it mentioned in the proposed rule. So first, it results in much higher levels of sea turtle mortality, double the level of sea turtle mortality of the least protective regulatory option that it said it was considering. And that presents much different implications for the recovery and conservation of sea turtles. And commenters couldn't have known that they were supposed to comment on what those implications might be because the service never indicated that it might adopt a regulatory standard with such a higher level of mortality. It actually indicated the opposite. And the service said in the proposed rule at J259 that it was rejecting the much narrower option for exempting skimmer trawls under 26 feet because that didn't provide enough protection for sea turtles, that it was too broad of an exemption. So how could commenters read that and then anticipate that the service would ultimately come up with a much broader exemption that provides much less protection for sea turtles? And that's the sort of flip-flop.
Because protection wasn't the only parameter that the agency had to consider. They had to consider other things like economic impacts on fisheries.
Correct, Your Honor.
What is the authority for that they had to consider economic impacts?
We don't disagree that economic impacts are relevant. Our point here is that they were not an independent basis for the rule. They balanced economics and conservation.
Protecting endangered species, economics.
I think that question's not necessarily presented here. I think that would be our client's position. The service didn't say in the rule that it trumps. The service doesn't say in its brief that it trumps. The service said it relied on multiple factors to reach this decision. And I think—
So I just want to understand, you're challenging the fact that they adopted a rule with a 40-foot boat limit instead of a 26-foot boat limit, because 26 was the only number that they included in their proposed rule. And I think you would agree, would you not, that they didn't have to put the number 40 in the rule in order to end up promulgating a rule that had that number in it?
Yeah, we would agree. I think what they had to say is that they might do a length other than 26.
Well, didn't they say that, JA 256, they said they might phase in the new TED requirements based on vessel size.
Mm-hmm. So
the largest vessels would be the first vessels required to install. Why doesn't that put people on notice that the vessel could be greater than 26, perhaps 40?
So the phased-in approach, the service explains that the reason for the phased-in approach is because it's going to take a while to produce TEDs. And so the phased-in approach was how to prioritize which vessels get TEDs first. And it explains that in that approach that the vessels that are not required to have TEDs right off the bat would be required to have TEDs under the rule. And it talks about, the issue with the phased-in approach is—
I'm just wondering why that doesn't give you notice that 40 is an option. Because when in that proposed rule, it said 26, but didn't say why 26. It never said because of safety, because of economics, because of anything. It just said, here's 26, maybe trawlers of 26 feet in length. And then there is discussion about other boat lengths. I don't know what else the agency is supposed to do to put you on notice that it could be 40, short of having to put in 40, which you agree they don't have to do.
So I want to add 2 points on that. So first, the phased-in approach, saying that this rule will require TEDs on all vessels and they'll have to have them at different times is very different issue than saying we're going to only require them on some subset and the other subset will never.
How is that different? Isn't that a phased-in approach? Let's start with the 40 length boats and then later we might make it 26.
The phased-in approach would, the way that it's presented is under this rule would require them on all vessels. And the only difference is the timing, the regulation would say all
So it's
vessels.
not exactly, but you also had noticed that it could just be trawlers in a different place. But this, if we're just talking about boat length, you're on notice about boat length.
I think
That it could change. It could be something greater than 26 because they're going to phase this in.
I think it would be that they would still require all vessels to have TEDs. And the only difference would be
So let's back up. There were 7 different alternatives. Some of them said all, some of them some subset of all. 2 of them said 26 feet in length. And I thought that your claim here is that we had no notice it could be 40 feet in length for the boat. And I'm just asking, why didn't you have notice of that based on this provision?
based on the phased in.
Yeah.
Because the phased in explains that the regulation would cover all vessels. And the only
You have
difference,
notice about all versus subsets. You don't contest that. You had noticed that it didn't have to be all vessels. It could be a subset. Do you agree with that?
yes. And so the other
Okay, so
point.
let's focus on boat
Okay,
length.
yeah. So the other point I want to make there is that the service explained that the reason that it had that 26-foot option is because it considers skimmer trawls under 26 feet to be different from all other skimmer trawls because they have.
Where is that in the proposed?
They explain that in the draft EIS. And I don't have the site handy, and I can find it.
Okay.
Yeah. So and they explain it in the final rule as well that they consider vessels under 26 feet to have unique data limitations, unique operational constraints that vessels larger than 26 feet don't. And so when they're telling commenters, we may consider vessels under 26 feet to be for an exemption for very specific reasons, that gives no notice that commenters should anticipate that they might exempt a different set of vessels.
Okay,
for
well,
different
that
reasons.
did it, but why doesn't this provision about the phasing in give you notice about 40 feet?
Because I think the phased-in approach, let's say that basically what they would say is we're going to require based on vessel size. It's saying that we will still require the TEDs on all size vessels, and the only difference will be the timing of when those requirements kick in under the rule. And that's different than saying we are not going to require them at all on vessels that are over a certain size.
Okay.
I see that I've used up my first 8 minutes.
All right.
Thank you.
Good morning, Kevin McCardle on behalf of the National Marine Fisheries Service, and may it please the court. I'll start with the logical outgrowth issue, unless the court would like me to start with a different issue. But first, I'd like to address your point, Judge Henderson, about environmental concerns not trumping, or economic concerns not trumping environmental protection. And that's not what happened here. This regulation is protective. It reduces sea turtle mortalities in comparison to the status quo by more than 1,000 a year. Most of the conserved sea turtles would be endangered Kemp's Ridleys, which the service disclosed in the rule. So this is a protective, beneficial regulation that contributes to species recovery. There's no requirement in the ESA that the agency achieve species recovery in one fell swoop by one action. It's permissible to take an incremental step, especially whereas here a greater step would have such a significant economic impact on fishery participants. So this was a rational decision by the service based on permissible factors, which is all that's really required. They achieved a significant conservation benefit, which no one disputes, while substantially reducing the economic impacts by up to 73%. And the final rule was clearly a logical outgrowth of the proposal, because the proposal was, hey, we're going to expand the required use to TEDs, TEDs, to all skimmer trawl vessels. The final rule expanded the requirement to a subset of skimmer trawls based on vessel length, which was an issue disclosed in the, which was a basis for the alternatives considered in the final rule.
Can I ask you a question about the Fox Television case from 2009? I think the district court cited it, and it's, big case. And I take it to mean that when an agency changes its policy for discretionary reasons, it has to explain the new policy, but it doesn't necessarily have to explain the new policy rather than the old policy, so long as it recognizes it's changed the old policy. If we think of the 2016 proposal as the agency's thinking in 2016, and then think about how it changed its thinking in 2019, I think Fox is maybe a pretty good case for you here. But I read it to, I think maybe it could be read to suggest that when that change happens, it has to be, when the change happens, it cannot be based off of circumstances that were central to the prior policy, unless it explains that. Do you agree?
Well, first off, I'm not sure if it's appropriate to apply Fox to a situation where you're talking about a change from a proposal to a final rule, because the issue there is you're changing a final policy to another policy. So I'm not sure if the whole rubric applies, but even if it did, it's a two-part test. You have to show, the agency has to show that it was aware of the change and give reasons for it. That's it, as far as I recall that case.
Give reasons for the change, and it has to give reasons for the new policy, not necessarily reasons why the old policy wasn't good enough.
Right, and I think,
and so I'm with you on that. And I take your, I want to come back to the first point you made, because I think there might be something to that too. But I take it to be maybe sort of an exception to that if the agency's old policy was grounded in some facts that haven't changed, the new policy may need to, what does that matter?
I'm not sure if that would matter. I mean, I think strictly speaking, the only requirement other than being aware that you're changing your policy is to give reasons for it. And they gave a good reason here. The facts did change. They received comments from, well,
I don't know, like they knew what it was going to cost before, and that understanding of what it would cost didn't change. They just decided in 2019 it wasn't worth the cost. And I take your argument to me that's a policy-making decision that they're allowed to make without having to explain away the old proposals.
Well, I don't think it would be fair to say that Fox stands for the proposition. If the agency says, hey, we were aware of these economic impacts before, but now we think it's a bigger deal. And we're going to draw the line somewhere else now because we're prioritizing to some extent these economic impacts more than we did before. That's perfectly permissible.
I think that's right. I think you're right about that. And can you return to the point that you made about maybe Fox doesn't even apply here at all?
I think the Fox rubric is aimed at when an agency actually changes its final policy from A to B. And here we just have a proposal, which the entire point of publishing a proposal for notice and comment is to solicit suggestions for change. So again, I didn't look at that case because it wasn't cited up here, but I have read it before, and I don't think it's meant to apply to a proposal, a change from a proposal to a final decision. I think, the logical outgrowth test is more the appropriate analytical rubric.
That might be right.
And I think it was clearly satisfied here. I mean, the Supreme Court in the Long Island Care at Home case essentially made the point that, not adopting a proposal is always a logical outgrowth of the proposal. And they cited this court's decision in the Arizona Public Utilities case, where the agency proposed to subject tribes to all of the same requirements as states, statutory requirements, and then in its final decision, only partially applied tribes to those requirements. So that shows that the Supreme Court also drew the connection between not adopting a proposal or partially adopting a proposal as being a logical outgrowth of the proposal. And that's especially true here when the decision is based on issues that were disclosed in the proposal. I mean, if you look at the table on JA 46, that starkly highlights the difference between the alternatives. And it shows that the major considerations were the number of sea turtles that would be conserved versus the economic impacts. Those were the competing considerations. And the agency disclosed that it was considering alternatives based on vessel size, and that the more vessels you include, the greater the conservation benefit, but also the greater economic impacts. And ultimately, its final decision was
Sorry, I don't see a table on JA.
246.
Oh, okay.
It's in the draft environmental impact statement.
Oh, I see.
It just, that starkly lays out central considerations, conservation benefits essentially against economic impacts. And it shows how those change as the alternatives, two of which were based on vessel size, under each alternative, two of which were based on vessel size. So the final decision wasn't based on some new factor, as in the Fertilizer Institute case, or even in CSX case cited by the plaintiffs. It was based on these specific considerations that were disclosed. So it was clearly a logical outgrowth of the proposal.
I'm sorry, is vessel size supposed to be in this chart? Because I don't see it.
Well, this shows the alternatives and the
Oh, you're saying within the alternatives, there were vessel size?
Yes.
26-foot alternatives.
right. They're discussed earlier in the draft EIS. So, everyone understood that the service was considering drawing the line based on vessel size, and that the competing considerations were conservation benefits and economic impacts. And the final decision was based on those same factors. So it's most definitely a logical outgrowth.
The your opposing counsel did not contest that economics can be a factor. So I think you two agree about that. What's the authority for that?
Well, I think the service could permissibly weigh economic considerations in deciding when to draw the line based on the statutory language in sections 4D and 11F of the ESA, which essentially give the agency discretion to promulgate regulations as necessary and appropriate in section necessary and advisable in section 4D, and as appropriate in section 11F. That, in conjunction with the Supreme Court's decision in Michigan v. EPA, clearly indicates that economic considerations fall within the broad scope of appropriate and advisable considerations that the agency at least has discretion to weigh. And that's undisputed, of course.
You think everyone could understand from the this goes to the logical outgrowth point. You think everyone could understand from the 2016 proposal that it was possible you might eventually draw a line about vessel size when only 2 of the 7 alternatives included vessel size?
Well, that's a significant, yes.
And why,
that in conjunction with the other portion of the proposal that Judge Pan discussed, where we said, hey, we're considering phasing in the requirements based on vessel size, with the theory that larger vessels have greater potential to interact with sea turtles in the fishery. So we'll get the greatest conservation benefit by targeting those larger vessels. And that's the same logic that the service used in the final decision. So those combination of factors, I mean, it's hard to imagine what would be a logical outgrowth if this wasn't, particularly when the case law is clear that the agency doesn't have to choose 26 feet. It didn't have to do that. It could change the number. So unless the court has any further questions for the reasons stated here and in our brief, the district court's well-reasoned judgment should be affirmed.
Mr. Eaton, how much time does Mr. Eaton have? How much take you?
Okay, thank you, Your Honor. So I want to address 2 points. So first, we're not talking about the option of not adopting a regulation at all. We're talking about an option of adopting some regulatory standard that the service never even mentioned was possible in the proposed rule. And the draft EIS, which is at JA 221 to 223, explains that it came up with this 26-foot standard because those vessels are unique. And that's what the service said it was contemplating might be an option for the final rule. That would have been a logical outgrowth. The service never said anywhere that it might come up with a number different than 26 feet in terms of which vessels are required to have TEDs and which are not. And if
So
they,
what do you think that they need to have said to put you on notice of this?
I think what they would have need to say is, here's a 26-foot option. We are considering other options for a yes or no required, not phased in, but our TEDs can be required at all.
Why does it have to be that exact?
I think because ultimately the outcome of the regulation is who is going to be regulated. And I think regulated parties, interested parties here need to know who might be regulated in the final rule to comment. And so there needs to be some indication that there's going to be some change. They don't have to say 40 feet.
But aren't you on notice? Because they were considering not having a boat limitation at all, a boat length limitation at all. So everybody who owns a boat is on notice that this might apply to them.
Perhaps, but for our clients, for conservation groups, the notice here is.
But you just said it's for the people who are going to be regulated.
Well, I think
everybody who owns a boat
I think
had
that,
noticed that they could be regulated.
The question here is not, we're not looking at particular, like the notice question is not about trying to break out the public interested parties into different sectors. It's a general.
I was just following up on your previous answer.
And so I think just to finish up, I think they need to open the door and say they might do something different than 26 feet. They might have to give some indication of what that metric was, say we're going to do length versus.
Just last question, but didn't they do that by giving you 7 alternatives, 5 of which meant all boats with no limitation on boat length?
They did not give any indication that they might come up with any length other than 26 feet. So the proposal, what they said is you could expect either all vessels are going to be covered or all vessels greater than 26 feet. And that matters because the vessels are operationally different. Vessels that are under 26 feet are fishing in very shallow waters, about 4 to 5 feet deep, where there are very few sea turtles. Vessels that in the 26 to 40 feet range are fishing in about 10 feet of water, which is like the hot spot for Kemp's Ridley turtles. And so the options in the proposed rule, either all or vessels over 26 feet, we don't have to worry about whether TEDs are going to be required where vessels are overlapping with Kemp's, because all of the options would require TEDs in that habitat. But then when you say the exemption is 40 feet, now you've got this set of vessels that's fishing in prime Kemp's Ridley habitat that nobody had any notice might be exempt from TED requirements. And that's just something that we would have raised in comments and discussed.
Can I ask you one question? Would you concede that the agency here does not have to explain why the 2019 rule was better than the 2016?
We can see that. Well, our argument,
What they have to explain is that the 2019 rule was reasonable.
what they have to do is when they give reasons for what they're doing, those reasons have to be based in fact. They can't be arbitrary. And they drew the line and said safety justifies setting a standard at 40 feet. But the findings in the rule and in the IS all said we only have safety issues. We've only identified safety issues for vessels under 26 feet. And they explain in the final rule that they've done extensive TED testing on vessels over 26 feet. And so they've got this testing information. They know from there, they haven't said that there are any safety or performance issues based on that TED testing information. And, we'd urge the court to look at that. Find the citations in the final rule where they talk about the testing are at JA 428 to 430 and 432. And the final rule directs readers to look at the final EIS for more detail. And that detail it's in the administrative record at AR 1689 to 1690. So when they said that that safety justifies a 40-foot standard, that choice is inconsistent with what the agency found. And an agency can't regulate where the reasons for regulation don't match up with its findings.
All right, thank you.
Okay, thank you.
Case number 22-1089, Vinyl Institute, Inc. petitioner versus Environmental Protection Agency. Mr. Gotting for the petitioner, Ms. Brown for the respondent.
Mr. Gowden, good morning.
Good morning. I'll reserve 3 minutes for rebuttal. First, just briefly, I'll address the merits of the test order, and then I'll turn to the 19B motion. 2 issues here. On the merits, when Congress amended TSCA in 2016, it gave EPA authority to issue test orders. EPA can do so without warning giving the test order recipients an opportunity to submit comments beforehand. However, Congress also put in place numerous guardrails to ensure that this test order authority is not abused. In other words, EPA has to show more than just a data gap. It has to show a data need. So along these lines, Congress established in Section 4 a stepwise process to ensure that expensive and time-consuming advanced testing would only be required after EPA had first considered less intrusive tiered approaches to inform whether there was in fact a data need. So as part of that tiered approach, Congress placed certain obligations on EPA. First, EPA must consider all reasonably available information regarding hazard and exposure.
Mr. Godding, we
Yes.
have a rule against reading the argument.
Oh, I'm sorry.
I'll help you because I have some questions.
Yeah, go ahead.
And I want to start with some questions that I think are pure questions of law. The EPA says its test order, and I'm reading from their brief 36 to 37. The EPA says their test order does not need to explain how it ruled out alternative testing methods. I know you disagree with that.
Yes.
What's your best reason for disagreeing?
If they have a conclusory answer and they say, "Oh, we don't know of any NAMs." We know under Section 4 and under the substantial evidence standard, you have to do more than a conclusory statement. You have to explain, what did I consider? What did I look at? And what is my reasoning? A conclusory statement, especially where you just rule out everything, doesn't tell me, the stakeholder, and it doesn't tell this court what they did.
Then the EPA says on page 38 of its brief, its test order does not need to cite substantial evidence in the test order itself. I know you disagree with that as well. What's your reason for disagreeing?
It would be the same answer. The statement of need, Congress set this up. The statement of need needs to describe how the information before it led to its conclusion. It has to explain its decision, and that comes from both the statement of a need specifically in Section 4.
What's the authority that says they can't just do that during litigation?
Well, this is an APA case. I mean, they're limited to the administrative record. And let's back up.
They say it can be in the record, but it doesn't have to be in the test order. And I know you think that's wrong.
Yes.
What's your authority for thinking that's wrong?
I think if you look at Section 4A2, Section 4, that section anticipates a statement of need that tells us what its reasoning was and how it came to decide that there was a data need. You cannot just say, just look at the administrative record. There has to be some explanation. It says describe, it says explain.
And now I'm going to go from pure law to law applied to facts. But, and by the way, I mean, of course they can't just explain post hoc in litigation.
Right, yes.
What is your single best example of the EPA not explaining itself well enough?
I think there are actually two. Just one.
Sorry, you can say two, but.
Yeah, I'll do one because I think they have a chart on page 8, JA010, where they identify some analogs, and then they identify with an X study. We don't know what the study is. It doesn't tell us what the study is. It just says an acute study for birds. So we don't know what that study is. And that's an important thing because acute studies can indicate low toxicity. They can be used to extrapolate to chronic toxicity.
I thought that was the Elovara study.
No, this is not the Elovara study. It's something else. So the Elovara study involved 1,1,2-TCE. That's the chemical at issue here.
Right, but I thought that was the acute study.
That is an acute study.
Okay.
But there's an X in that chart that indicates there's also an acute study for 1,1,1-TCE, an analog. We don't know what that study is.
Is this the chart that has, I think, 7 studies?
Yes.
7 studies. And did you know which studies those were?
No.
Prior to, I know you're saying you didn't know what this one study was.
Yes.
You didn't know what any of those 7 studies were.
No.
Right?
And we still don't. We still have to guess. Now that we have our chart that they pointed to in the administrative record, which was not cited in the test order, we can guess it's the Dow study, but we still don't have something connecting those two.
Please, we're in a world where there's going to be some testing. Okay, the chemical needs,
Yes.
we need to know something more about the chemical. Can you walk me through a chain of events where some lower level or screening tests occur and they don't lead to
Yes.
vertebrate testing?
Yes. The way they set it up is a stepwise process. Let's say you have 3 or 4, tiered tiered things you could do. If those arrows are all pointing to low toxicity, or it's actually the weight of the evidence, it's not even all the arrows. If the weight of the evidence and those arrows are pointing towards low toxicity and low exposure in frequency in the environment, then EPA should be asking itself, should we order this more expensive, year-long, multi-year-long testing? And so that can be done through acute studies and extrapolating to chronic. It can be done through doing in vitro testing. It can be looking at analogs. And so when you put all that together, we're not asking for a threshold determination on unreasonable risk like you do under 4A1. But we're saying, look at all of the information, where are the arrows pointing? And if they all kind of seem to be pointing towards low toxicity and exposure, then maybe we shouldn't be doing a year-long test at 200 grand.
I think I understand that now.
Yeah.
Has the testing started, the quail testing?
We're still in the preliminary. We haven't started feeding the quails.
What's the risk that this is going to become moot before we decide the case?
So the testing as of right now, we think will be done in late summer, early fall, with the final report later than that.
So if we're going to rule for you, we better do it
somewhat soon.
Before summer.
Yes.
When do the quail die?
I've asked that question. It's not quite clear, but it would be at the end because you have to have them live. It's a chronic. They have to eat over time and then actually lay eggs. So
you start poisoning them before that.
I wouldn't put it that way, Your Honor, but yes, but not so. I mean, they have to survive. They have to live. I mean, it's a chronic study.
So if we can go back to what you were saying about that chart. I mean, the statute says they have to identify the need for the new information, describe how information reasonably available to the administrator was used, et cetera. You just seem to be asking for a level of specificity that it's not clear to me is required by the statutory mandate.
So if you look at the plain language, it has a lot of, guardrails that I was discussing. And so, everything from, it has to do with best available evidence and a weight of the evidence. I think to address your issue though, EPA, this is a very discrete issue. It's, what's the impact on birds? And I think EPA is certainly qualified to quickly narrow the NAMs, those new approach technologies, and the studies that would be relevant, down to 2, 3, 4 that they have to discuss. So we're not saying, I think as EPA argued, you have to look at this huge mass of evidence. It's a very discrete question. And again, because EPA can narrow it down pretty quickly, but then it does have to tell us whether it's the NAMs, whether it's the studies, what did they think? What was their reasoning? And I'm not seeing that in the test order or even in the administrative record.
Didn't they say at JA9, they explain the table. They say, as shown in the table below, terrestrial environmental hazard data were identified, et cetera. There seems to be some discussion in addition. But I guess what I'm more interested in is what's the legal principle you're trying to apply here? Because the legal mandate's pretty broad and you're saying, well, it needs to be more specific. So how do I know what's specific enough in your view?
I think that the test order is so conclusory if you use that as a jumping off point. I do think there has to be enough that we can sit down and understand, so for example, with an acute study, they could say in a paragraph, here are our criticisms of this study. This is why we're not going to listen to it. We're not asking for a book or anything.
Sounds really specific.
But I think that's what Congress said. If you look at the plain language of the statute, they place some significant burdens on EPA to do this. And I think it's because they didn't want EPA just issuing test orders. Because they also have an option to do a consent agreement.
No, I understand that. I just don't quite understand what legal standard you're asking us to apply. I mean, it's just a substantial evidence.
Yeah, it's a substantial evidence.
I don't see why this isn't substantial evidence.
So
You want just much more explanation and specificity, but I don't know why I need that just to find substantial evidence.
I mean, if you look at the few cases where this court has implemented substantial evidence standard under TSCA, this court has gone into great detail, looked at the administrative record, looked at the explanations that the agency gave, EPA, and then also looked at the record for contrary evidence. I mean, it is not arbitrary and capricious. And so the flip side of that coin is that the agency has to do its job. It has to identify on some level the facts that it considered, what its reasoning is, what judgment calls it made, and how it dealt with the contrary evidence. That is what Congress imposed on EPA. That is the plain language of the statute. See, my time is up. Thank you.
All right, we'll give you a couple of minutes to reply.
Thank you.
Brown?
Morning, may it please the court. Laura Brown on behalf of Respondent EPA. I'd like to begin by addressing the merits of the test order and then turning to the 19B motion. Now, TSCA requires EPA to assess the hazards and the exposures of 1,1,2-trichloroethane to birds. And in the test order, EPA explained that it conducted a systematic and comprehensive search on the avian toxicity chemical could potentially pose. And it identified one study, the aloe vera study. And that study concluded that the chemical killed and deformed chick embryos when it was injected into their eggs. EPA also explained in the test order that it had identified monitoring data that showed that this chemical is in the environment. It's in the air, water, soil, biota, all of which birds are exposed.
How much of the test order was so generic that you could copy and paste it into the other 74 chemicals that you've recently ordered testing?
The statement of need is specific to the work that was going to be done here, the information that was required and the explanation of why it was required. Procedures that are going to be required, the protocol is specific to these tests, but there is nothing in the statute in Congress.
Would it be fair to say the vast majority of the statement of need could be copy and pasted into 74 other chemicals?
I disagree.
Okay, tell me why.
The statement of need has to meet certain statutory requirements. However, Congress did not expect or dictate that EPA create some sort of exhaustive decisional document. The statement of need has 4 requirements. Identify the need. Explain how information, reasonably and available information, was used to inform EPA's decision to order the test. Explain why you're requiring vertebrate testing, and explain why you're issuing an order. Those are unique to this circumstance. And those explanations do not have to be complicated and long. Here, EPA identified the need. That one test they could find on the toxicity of 1,1,2-TCA showed it was toxic.
I'm with you on
Yeah.
the 1979 pheasant study. It's good. It's something for you. Can I ask you the 2 questions that I asked your opposing counsel about these 2 quotes from your brief? And I'm at 36 to 37. The first thing you said is your test order does not need to, quote, explain how it ruled out alternative testing methods. Now you heard Vinyl's answer to that. What's your response?
There's nothing in the statute that requires EPA to explain how it ruled out alternative information.
And then you said on the next page, page 38, your test order does not need to, quote, cite substantial evidence in the test order itself. Response to that?
EPA can rely on the record in support of the statements made in the order. The standard of review for a test order is substantial evidence taken in the record as a whole. Now, petitioner would like to avoid considering the statements in the record that directly support the statement that EPA made in the record.
But you're distinguishing between the record and your explanation in the test order, right?
Well, I believe, yes,
think you
yes, I am
So-
distinguishing.
And then, so let's say that you won't like this, but let's say that I disagree with you about those 2 pure questions of law, whether you need to explain how you ruled out alternative test methods and whether you need to cite substantial evidence in the test order itself. if I disagree with you there, I think I have to vote with the petitioner here. Would you agree with me?
Well, I would.
If I disagree with
If
you.
you disagree with me, yes, but I'm going to try to convince you to
Okay,
not
go for
disagree
it.
with me.
Go
Okay.
for it.
So I would point you to section 424J of TSCA. And in that section, the statute requires that EPA list all of the studies it considered in conducting a risk evaluation and describe the results of those studies. That is not required in section 4 for a test order. I mean, Congress, Congress, the purpose of amending TSCA was to assist EPA and to obtain the information it needs to conduct a risk evaluation, for which EPA must have 20 ongoing at a time and is subject to strict statutory deadlines. Congress was not going to require, it was clear in the legislative history that Congress is not creating procedural and burdensome processes, time-consuming processes for EPA to get this information. That was one of the explicit intents of Congress in amending TSCA and giving EPA this authority to issue test orders. And so for petitioner and Amici to assert that EPA needs to go and explain every study it identified, explain why every new approach methodology is inappropriate, is well setting EPA up to the issues that it faced before TSCA and obtaining the information it needs to quickly conduct risk evaluations as Congress has required it to do.
I take their argument to be a little different than that. I think maybe if the test order had said, look, these are the 2 or 3 closest, most relevant studies that are out there already. And here's why they're not relevant enough. Or here's why they're not good enough. Then I think that might have gotten you there.
Well, I think they did.
Okay,
So
tell me where they did that.
Comprehensive, extensive search for avian toxicity information. This is described in the test order. It explained the databases it searched. It said, we found one study, the Olivera study, but it's not good enough. And I think petitioners would agree it's not good enough. And EPA explained why it's not good enough, because it is an acute study. That means it's only the birds are being subjected to a very high dosage of the chemical. And it's in their eggs. And
I'm with you on the 1979 pheasant study.
Sure, but it's the only study. So they discussed it and they said, this is why it's not acceptable. And they said, we searched for other analogs and they identified them in the test order. Analogs are similar chemicals that they could use to.
I mean, this does get awfully into the weeds. And I think this case probably has more to do with pure questions of law, but I will ask you, I'm at JA41, the order is addendum E, and I think it's describing, I think this is the 1979 pheasant study. But it is a pheasant study about 111. Does that ring a bell at all?
What? CA? I'm sorry, is that what you said?
RATCA.
Yes.
And so EPA presumably decided that this study wasn't enough to better understand the effects of the similar chemical 112-TCA. I get it?
Correct.
It's fine. I mean, you're going to tell me the reason, but why wasn't the reason in the order?
The reason was in the order.
Okay.
EPA explicitly stated we need chronic toxicity data. And this is important because I think it's somewhat lost on non-toxicologists, but chronic toxicity data, which is clearly stated, the need EPA has is for chronic toxicity data. If birds are exposed to this chemical in the environment at little tiny doses for their whole lifespan, is it going to have an adverse effect on their eggs, on their growth, et cetera? The Olivera study.
Judge Walker's question was, are there chronic studies for the 111 TC?
No, they're not.
What about, what was the study X in JA10?
That's the study that Judge Walker is referring to.
Okay,
So
it's not chronic.
it's not chronic.
I see.
EPA explained they didn't find any chronic studies for any of the similar chemicals, and they need chronic data. So whether or not they named.
There is a table with 7 studies, and I honestly can't tell you the JA number off the top of my head. I think that your opposing counsel was discussing it, and he said he can't figure out what those 7 studies even are. Should he have been able to figure it out?
Yes, I think he should have.
Awesome.
I will say it's a little hard to find. And so one point I wanted to raise is that I do not think it's post hoc rationalization for counsel to identify in the record where support exists. So I am pointing you,
You're distinguishing again between the record and the test order, right? And the record wasn't released with the test
oh,
order.
I thought you were asking about the.
Well,
Sorry.
but then I, see, okay, you're,
Okay.
you're right. I pivoted for a second there.
Okay, well, I will say in the test order, you're right. The studies aren't identified. The ones that EPA found to be irrelevant were not identified. The one that it found to be relevant, but not enough because it was an acute exposure, and it explained the limitations in the test order. It shouldn't have been a surprise to petitioners to understand why EPA couldn't rely solely on the Elevera study.
So are you conceding that Vinyl needed the administrative record in order to understand the order?
Nope, I am not conceding that. First of all, the Vinyl Institute had access to the analogs EPA searched for data. EPA in its test order explained step by step how it looked for these studies. They could have repeated that process.
They never named the studies.
They did not name the studies.
Other than the 1979.
That's correct. Because they found out they determined they were irrelevant. I mean, we're at this point where is EPA's burden to explain everything they did in a test order. And the purpose of the test order is the reason Congress has given EPA this new authority is to make it simpler, the process simpler for EPA to get the information. I really don't think that squares with the legislative history, the actual language in the statute, describe how you used available information. It does not say, explain how you ruled out using existing studies and identify those studies. Section 24J, to some extent, does that. It says, EPA, when you're issuing the risk evaluation, which will ultimately potentially regulate this chemical, then EPA has more. It has to show more of its work.
But I think on a spectrum between that extreme, listing every book, every article you looked at, and take our word for it, other than the 1979 study, we're not going to give you any specifics. And you have to sue to find out more. I think that's a broad spectrum, and I think probably the standard is in between there.
Well, I would say I don't think they had to sue to find out more. They could have requested the record from EPA. They also had the opportunity to submit information to EPA, and I know my time is up, and that goes to the 19B motion. But for these reasons, unless council has further questions, the petition for review should be denied, and the 19B motion should be denied.
Mr. Gowdy, why don't you take 2 minutes?
Thank you. Just a couple of points to go back to kind of the law here. The way Congress set this up, let me back up. What EPA is saying is that there is a data gap. There is no chronic data. So Congress recognized that that would happen. So what did it do? It said, you don't go straight to advanced testing. You can use tiered approaches, including acute studies, to inform that issue. And again, it goes back to where are the arrows pointing? What is the weight of the scientific evidence using indirect methods? So the fact that there's no chronic testing out there on 112 TCE, Congress anticipated that and said, we're going to do a stepwise approach here.
So, but why isn't it enough for them to say, we need this type of study to understand the effects, the chronic effects on the birds, and there isn't one out there, so now we need to do one?
I think that's what I was just talking about, that there are other ways to get to that information and that answer without requiring expensive, time-consuming advanced testing. You do it through things like acute tests, like that analog, the 111 TC.
Or computer modeling.
Or computer modeling.
Vitro,
in vitro, exactly. And they were supposed to.
But they have a data gap spreadsheet that explains what they looked at and what's missing from that. I mean, it just seems like there is a lot in the record here, and I'm just trying to understand, like, why? What is the basis for needing so much more?
And because I think Congress told them that they had to engage in some level of discussion to justify the need, and instead of us having to take their word for it. I think if you just look at the test order itself, there's a lot of just conclusory sentences where we just have to say, okay, we believe you. And that is not what plain language of the statute asks.
I understand you to be saying a lot of this needs to be in the test order. And I guess, isn't that just a formality? Like, if this testing is needed and it's supported by the record, why does it have to be in the test order?
I think because Congress used the word describe and explain,
But you're talking about the level of detail in describing, explaining.
It's
You're
not-
asking for a higher level. It just seems to me, isn't that a formality? You want us to remand it so they can take the information that's already there and put it in a different place?
I don't think they have the information yet. If you look at the administrative record, they don't explain. We have a chart of NAMs, but there's no explanation why they ruled out, at least there are a couple, two key ones, we think. If you look at that big spreadsheet of all the studies, there's no explanation. What about that 1.1 TCE test? Were there any other studies that you thought about? There's no explanation. We just have charts. And so under the substantial evidence standard, even in the administrative record, they still have to point this court to something where they did some analysis. It's kind of like they started it, but they didn't finish it. And I don't think this is a failure to explain case. It is a failure to explain case, but I also think it's a failure to show substantial evidence. We don't have their explanations.
I'm interested in what you think the standard of review is for this particular legislation. Do you think it's changed from when CMA said this requires a searching substantial evidence, rigorous substantial evidence, almost a sui generis substantial evidence, and you haven't even discussed that? Do you think the standard of review has changed since CMA?
No, I don't think there was anything in the amendments that I'm aware of that changed the substantial evidence standard.
It's not just substantial evidence. It's a heightened substantial evidence.
Yes.
All right, I'm glad to.
Yeah, and in fact,
Stay with me.
And in fact, typically the substantial evidence standard under the APA is not a weight of the evidence. Congress said this is a weight of evidence analysis. That's the plain language. Thank you.